Welcome to Canadian Justice. I'm Christine Van Gyn. Today we're talking about a story out of Alberta. A pastor at an Edmonton area church was put in prison for 35 days for violating public health measures meant to contain the spread of COVID. The pastor is going to trial in May for allegedly holding church services that broke a restriction on the size of gatherings. Provincial regulations restrict in-person worship at churches to 15% capacity. Pastor Coates remained in jail for such an extended period because he refused to agree to the main condition of his release, that he and his church abide by the multiple orders that they have received to follow the guidelines for in-person worship. The government ultimately dropped this condition, and Pastor Coates has now been released from jail along with a $1,500 fine. Today we'll be examining what exactly happened in this case and what will be happening next. We're going to be joined by Ontario lawyer Chris Kinsinger, Alberta lawyer Tom Engel, and John Carpe, the head of the Justice Centre for Constitutional Freedoms, who's representing Pastor Coates in this case. Thank you all so much for joining me today. Mr. Kinsinger, I'd like to start with you. There have been many people who have violated public health orders, but this was the first time that someone's been put in prison for such a long period. And I'll note that the imprisonment is all pre-trial. So what made this case so different?
There's a couple of factors, Christine, that have set this case apart from others. The one is that, as I understand it, at the end of the day, the underlying offense for which Pastor Coates was charged would not have resulted in prison time. Now, the reason that he was held in custody is because he violated what's called an undertaking. Pastor Coates disputes that he consented to this undertaking and therefore does not believe it was lawful. But even had the trial gone through and he had been found to have violated...
What was the undertaking that they say he violated?
The undertaking was effectively that he follow all COVID-19 regulations and guidelines as it pertained to places of worship. So in Alberta, that would mean a 15% capacity limit, along with strict requirements for physical distancing and mask wearing.
Okay, so he violated that undertaking and then he would not consent to making the subsequent undertaking. That's sort of what sets this apart. Mr. Engel, I'd like to turn to you. You have said that you're in favor of the charges that have been brought against Pastor Coates. Can you tell me why? And in particular, do you support the lengthy time that the pastors spent in prison pre-trial?
Well, I support it in this way. If the government is going to enact a law, then you have to enforce it. You have to enforce it equally. So when somebody offends the law and you don't enforce it, then it brings the administration of justice into disrepute. The law becomes meaningless and toothless. And so you can't have some people being charged and some people not being charged for breaking the same law. And you know, this is not the only case in Alberta where people have violated this law and not been charged. There have been rallies. There have been cases where I recall 3 county officials in northeastern Alberta got together in a restaurant, brazenly violated the law, and did it for publicity about their opposition, I think, to the law, and they weren't charged. So this is a real problem, the unequal enforcement of the law. Secondly, the only reason he was held in custody is because he wouldn't sign an undertaking that he would stop breaking the law. And in that kind of situation, it's not surprising that you get detained in custody pending your trial. So that's what happened there. If he had signed it, he would have been out and spent no pretrial time.
Mr. Carpe, we only have about 40 seconds left. Can you explain briefly, and he's out of prison now, so why were some of the charges dropped ultimately and he was released without conditions?
Well, the Justice Centre's lawyers negotiated with the Crown, and this is quite common in criminal law and other areas of law, and the Crown withdrew one of the charges of violating the Public Health Act. The other one's going to trial in May, and it will effectively be the government's health orders that are going to be on trial, along with Pastor Coates and his church.
And he ended up with a $1,500 fine, correct?
which he won't have to pay because of recognition of the time that he did spend
I
in
understand.
jail.
Okay. Well, we're going to continue this conversation, which is a really important topic, right after these commercial messages. Welcome back to Canadian Justice. I'm Christine Van Gyn, and we're talking about the recent arrest and now release after 35 days of an Alberta pastor who held church services that were above health limits, the health capacity limits. Now, Mr. Carpe, I'd like to ask you about these services themselves. Can you tell me about how they were running, how many people were there, and did the church have any health measures in place?
The church did have hand sanitizers, and they also had social distancing opportunities for people that are vulnerable to the virus that want that. There's sections of the church that were, plexiglass and whatnot. This church, like so many other churches and so many other businesses and people, in March of 2020, when we had all the fear mongering from Neil Ferguson of Imperial College that this was going to be this unusually deadly virus that was going to kill millions of people, everybody was fully compliant. But with the passage of time, the government's own data and statistics tell us that COVID is not the unusually deadly killer that was predicted 13 months ago. So by the summer of 2020, the church was simply holding normal church services, which of course are only attended by people that are not afraid of the virus. And that's 90% of the population is not threatened by it. And if you're in the 10%, it's very easy to avoid church. So they started having normal, regular church services as of the summer of 2020. And that has continued through, and I'm told from media reports that the church continues to have ordinary, regular church services.
So these new services are without the distancing, without masks, correct?
That's my understanding.
Okay. Now, Mr. Engel, do you have a response to that? Do you have any concerns about whether or not this is sort of infringement on the free exercise of religion when we're in the face of what, in my view, is a deadly pandemic?
Well, I think it engages the constitutional right to freedom of religion. But what happens is you have to weigh that right against the right of the public to be protected from COVID-19, and you have to weigh it against the purpose of the law. Now, I understand that one court has done that already and decided that it doesn't violate the Constitution, or that might have been an interim application. I'm not entirely sure.
I think they've mostly been
that.
Injunctions thus far.
Pardon me?
I think my understanding is there have only been injunctions related to church limits so far.
Yeah, but constitutional lawyers who are a lot smarter than me, I suppose, or more educated than me on constitutional law, I think most of them have said that it would pass constitutional measure. Then that means that it's a reasonable limit on the religious freedom right.
Now, Mr. Kinsinger, I want to follow up with you about that, about the concept of reasonable limits, which is under Section 1 of the Charter. In my view, I think that a hard cap, which is what we had in Ontario, is maybe not rational given how large some churches are. 1,000-person capacity churches maybe shouldn't be subject to a 10-person hard cap, but is a capacity limit like 15%, 50%, is that a more reasonable limit on the free exercise of religion?
Yeah, and I'll state at the outset, Christine, I'm not an epidemiologist and I'm not going to pretend to be. My understanding of what the generally accepted consensus, though, is that this virus does spread through close in-person contact. And so on that basis alone, I think it's difficult to argue that any and all restrictions will not be demonstrably justified. It does seem that we need to, as you say, put some restriction here in place in order to curtail the spread of the virus. The question is going to be what that is. Hard caps are more difficult to justify because, as you say, there are some churches that have spaces large enough that physical distancing can be adequately maintained. And so when we look at the data, it would appear that where those measures are followed, that the risk of outbreak goes down considerably.
Now, we've only got about 20 seconds left. Mr. Carpe, can you just tell me about how the arrest actually happened? Did it happen in the church or his home?
Well, he was asked to come down to the police station, and he was arrested and jailed. If I can respond briefly to the constitutional standard, I agree entirely.
John, can I just let you respond after the commercial break? We've got
Sure.
a hard break. We'll be right back after these commercial messages. Welcome back to Canadian Justice. I'm Christine Van Gyn, and we're talking about the recent imprisonment and release of a pastor in the Edmonton area. John, before the break, I just wanted to allow you to wrap up your point about whether or not capacity limits is a reasonable limit on our charter right to worship.
Well, in the past 12, 13 months, we've had a lot of rhetoric from the government about science-based policy and evidence-based policy. But what's going to happen at trial, May 3rd to 5th, in Alberta Provincial Court, is the government's going to have to actually produce the evidence and persuade the court. And thus far in the last 12 months, you hear the rhetoric about science and you hear rhetoric about evidence-based public policy. When you actually ask what science are you relying on specifically, you get completely stonewalled. And I've been experiencing this for the last 12 months. Governments do not answer very simple, straightforward questions. So amongst the issues in court, the government will have to actually prove with evidence that COVID is an unusually deadly killer. They can't just engage in fear-mongering by way of news conferences. They're also going to have to prove that healthy, asymptomatic people are significant spreaders of the virus, which in our view is not backed by science. And they're also going to have to prove that the lockdowns are actually saving lives. They can't just assert that. They will need to produce evidence. And lastly, and most challenging for the government, they'll have to show that the lockdown measures are actually achieving more good than harm, because that's another part of the charter analysis.
And absolutely, the burden lays with the government to justify the limits. So I look forward to watching that. Now I want to turn to the question of the bail and the pre-trial imprisonment for 35 days. Mr. Engel, you're a criminal lawyer, and this pastor was kept in jail for 35 days for non-violent offense. Setting aside your views on whether or not he should have been charged, what do you think of the condition that was placed on his bail? Is it unusual to put a bail condition like that? And was this an unusually long time to stay in prison pre-trial?
It's not an unusually long time. You can be in pretrial custody for years before your trial takes place. But look at it this way. What's happened here is that the accused had decided that he was going to continue to violate the law. I'm sure that was the position in court. And if you get charged for an offense and you get taken before a justice of the peace or a judge, and the judge hears, yeah, and as soon as I get out, I'll just keep breaking the law. It's not unusual that you're not going to get out for obvious reasons.
Now, Mr. Kinsinger, you've written that what was especially troubling to you about this case was that the government had chosen to send Pastor Coates to prison instead of just issuing fines. Can you elaborate on what your concerns were there?
Absolutely, Christine. I think if you look at the range of options that was available to law enforcement in this case, as you said, the one option was to hold Pastor Coates in custody until his trial. The other was to simply issue fines. If the goal of law enforcement was to encourage compliance with the law, or perhaps more to the point, to discourage noncompliance, I don't think arresting Pastor Coates ultimately worked. Pastor Coates' church continued to meet at full capacity, and many other churches joined them in solidarity.
And it seems to be continuing now today.
Not just in Alberta, but in other provinces as well. Absolutely. So if the goal here is to promote compliance, if we look at other provinces, fines seem to accomplish that much more than taking an individual, a pastor and a husband and a father, and taking away their personal liberty by holding them in custody until a trial.
Now, John, I have seen sort of similarly unusual conditions, sort of infamously these Toronto barbecue cases where I think one person who was there protesting a bail condition he had was that he get a COVID test. And I think the owner of the barbecue restaurant was told he needed to stop posting on social media in order to have a condition on his bail. What are your views, just in 30 seconds, what are your views on conditions like that?
Well, we've got one of the central principles is that a person is innocent until proven guilty. So certainly for anything pre-trial, pre-conviction, I would lean towards saying that restriction should not be onerous. At the same time, I'm kind of a law and order guy, and I think that the law should be obeyed and consequences should be imposed. But the most important thing in the big picture is that the highest law of the land is the Charter, and governments have not done their homework on proving that these lockdown measures are necessary, beneficial, effective, bringing about more good than harm. And this is a test that they need to meet even without getting sued.
Mr. Kinsinger, I want to start with you here. Is there a middle ground here? Do you think that there are some health measures that are warranted? And how does government strike the right balance?
Yeah, my personal view, Christine, is that some measures here are going to be warranted. As we discussed earlier on in the program, that some capacity limits are likely going to be appropriate. And in general, courts are going to be deferential to governments on those sort of questions. But I do agree with what John said, which is that governments need to always justify these restrictions on the basis of evidence. Now, John and I might disagree a little bit on whether or not the evidence supports some of those restrictions. But one thing that we need to bear in mind is that these restrictions need to be very carefully tailored. In the language of Canadian constitutional law, they need to be minimally impairing. The other thing they have to be is proportionate. And that means that roughly the cost of the restriction needs to be proportionate to its benefit. And even if that is the case now, if the cost is proportionate, we should not expect that to be the case forever. If measures intended to slow the spread of the virus work, then the benefit is going to decrease while the cost is going to increase on claimants. So it's a question of when the balance shifts, not if.
Mr. Engel, I want to turn to you. You've said that you think not only should Pastor Coates be charged, but that the government should actually charge all the people who attend the church. Can you explain what you think that would achieve?
Well, what it would achieve is hopefully compliance with the law. If the people coming out of the church were all ticketed with offenses under the act, and which would carry fines with them, and then they came back the next week and did it again, they would just continue to get ticketed and perhaps even taken into custody to justify their release. So the law is supposed to be enforced. It's supposed to deter non-compliance with the law, and it just isn't. It's really a joke that this one pastor gets charged, and there's a few fine tickets being handed out elsewhere, and then you have just basically civil disobedience, rampant civil disobedience in other churches, and they're not doing anything. The RCMP go to Grace Life Church and sit in the parking lot and watch the defiance of the law and do nothing. This is not good for the administration of justice.
John, I want to turn to you. I want to ask you specifically about the bail conditions. Why is it that Pastor Coates wouldn't agree to the bail conditions? I mean, buildings already have capacity limits, for example, fire codes. This is obviously a lower limit, but I assume Pastor Coates doesn't object to a fire code. So why not just run more smaller services or run online services?
Fire code's different in the sense that you can plan for it, and when a church, builds the building, they will decide whether they want something that can hold 200 people or 2,000 people. These arbitrary health orders that change from week to week, month to month, is not something that you can account for in the same way that you can for the size of a building, knowing ahead of time what the fire code restrictions will be. Fundamentally, what it boils down to is that these health orders are unscientific. Governments have not put forward evidence in the last 12 months as to lockdowns actually saving lives. The evidence that we do have is that this is not an unusually deadly killer that warrants these kinds of health measures. So fundamentally, what it boils down to is Pastor Coates is not willing to agree to abide by unscientific and unconstitutional health orders that violate his human dignity and his fundamental charter freedoms.
That's all the time we have. Thank you all so much. We've heard today about the story of a pastor in Alberta who was arrested for refusing to abide by public health guidelines, and about how government restrictions on in-person religious worship limit our constitutionally protected right to freedom of religion. Governments can pose limits on our rights, but only if those limits are rational, proportionate, and impair our rights as little as possible. At Christmas, my charity, the Canadian Constitution Foundation, was involved in litigation with a Toronto-based church that could not hold a Christmas service because there was a hard cap of 10 people. Despite the fact that this Toronto church could hold over 1,000 people, they were limited to just 10. The case has now ended as Ontario has revised the rule to allow for capacity-based limits instead. So does a 15% capacity limit get the balance right? Is it a reasonable limit in the name of public safety and preventing the spread of a deadly virus? Or does this limit go too far? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.